Hello and welcome to the Kenneth for Cam Law Office Legal Podcast. In this edition, it's part of a three-part series dealing with the major municipal court and criminal cases that have been decided in the past year. And it's part of the New Jersey State Bar Association and Institute for Continuing Legal Education program on the recent criminal cases in the past year. And we now look at the search and seizure laws, and in particular school searches. Does the Fourth Amendment prohibit a school principal from searching a car on school grounds? No. State versus Best. A school principal may search a car on school grounds if they reasonably suspect criminal activity. The appellate division held the school principal may search a student's car parked on school grounds whenever, under the totality of the circumstances, the principal reasonably suspects that evidence of a criminal activity be found in the vehicle. In light of the strong state interest in maintaining order, safety, and discipline in the school, neither probable cause nor a search warrant was required. The next case is about a daughter whose father probably will not be paying her college tuition. Can the police stop a car based on a daughter's call that dad is driving drunk? Yes. New Jersey Supreme Court, State versus Amelio. Based on the report to the dispatcher by the 17-year-old daughter, who identified herself, reported her father was driving drunk, and described the vehicle, there was reasonable and articulable suspicion of an offense to support the constitutional motor vehicle stop by the police. That's State versus Amelio. In a gang neighborhood, at a traffic stop, is a pat-down of a passenger always prohibited? No. The U.S. Supreme Court in Arizona versus Johnson, I'd say a passenger pat-down during a traffic stop is forbidden if there's a belief the person is a gang member and that gang member is armed and dangerous. The pat-down did not violate the Fourth Amendment's prohibition on unreasonable searches and seizures. We next look at Miranda rights. And the defendant is called by an investigator and says, listen, we'd like to come in and ask you some questions. We're looking at the guy. Goes to the police, is given to Miranda, and then after he gives a formal statement, he's then told, the victim also gave us another accusation. Now it's against you. And they started the Miranda again. Is that confession admissible? And the New Jersey Supreme Court said yes in the Nyhammer case. Previously, the appellate division said it was not admissible. Arrest warrants. Does an arrest based on a mistaken invalid warrant suppress drugs and a gun found? Let's see. Nope. When police mistakes leading to an unlawful search are the result of isolated negligence rather than a systematic error, the exclusionary rule does not apply. That's Herring versus United States. In DWI cases, sometimes there's a statement by the police that the person crossed the double yellow line. How about drifting within a lane? Let's see, but not crossing the line. Does that justify a stop? And at least in Mercer County, drifting within a lane supports the DWI stop by the police. In this law division opinion, the law division held it is not necessary for the state to demonstrate that weaving in a lane would affect the safety of other drivers. DWI trials. Can the court order the sequestration of a defense expert? No. State versus Popovich. Here, the defendant's conviction was reversed. The trial court erred when it ruled that defendant's expert was subject to a sequestration order and would not permit the expert to watch the trial testimony. Can the police always search a car under exigent circumstances? Depends. That's based upon a case-by-case basis. the New Jersey Supreme Court in State versus Juan Flores, whether exigent circumstances exist is to be decided on a case-by-case basis with the focus on police safety and the preservation of evidence. The court also determines that a warrant obtained by telephonic or electronic means is the equivalent of an in-person warrant and does not require proof of exigent circumstances. That's State versus Juan Flores. Should police be able to search a passenger compartment of a car after the suspected driver and suspended driver is handcuffed and locked in a police car? Well, at least in Arizona, no, based upon the U.S. Supreme Court case of Arizona versus Gant, decided April 21st. No search of the passenger compartment of a vehicle incident to a recent occupant's arrest unless it is reasonable to believe that an arrestee might access the vehicle at the time or that the vehicle obtains evidence of the offense of the arrest. So they can't just search the car because they want to check it out. That's different from the New Jersey Supreme Court case of Eckel. What is constructive possession of drugs? Sometimes the police will indicate, well, if you're able to touch it, that's constructive possession. Well, the New Jersey Supreme Court in State versus Reeves, in addressing constructive possession, says that it's such possession that can be constructive, meaning that, quote, although the defendant lacks physical or manual control, the circumstances permit a reasonable inference that the defendant has knowledge of its presence and intends and has the capacity to exercise physical control or dominion over it during that span of time. So they have to show some sort of intent, that they had the intent to exercise control. And in Reed's case, they also indicate that the issue of constructive possession is a decision by the trier of fact in the Superior Court, the jury, not an expert testifying that I believe that everyone had constructive possession. And our last case deals with vacating the guilty plea, or actually withdrawing a guilty plea prior to sentencing. And the New Jersey Supreme Court said there's 4 factors to balance an evaluation motion to withdraw a guilty plea. 1, whether the defendant has a colorable claim of innocence. 2, the nature and strength of the defendant's reasons for withdrawal. 3, the existence of a plea bargain. 4, whether withdrawal could result in unfair prejudice to the state or unfair advantage to the accused. Let's see. For representation in criminal matters, call the law office of Kenneth for Kamen, 732-572-0500. We're at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. On the web at www.njlaws.com. That's njlaws.com, and benotguilty.com. That's benotguilty.com. Thank you and good luck.